And she goes on and on multiple times saying, Judge Glanville already dealt with this. Judge Glanville already talked about this. Judge Glanville told the state and the prosecution that they should be on time. Judge Glanville told them they were limited to a certain amount of witnesses. Judge Glanville told them this. Judge Glanville told them that. And we're seeing Judge Whitaker even admonishing multiple times, and it's still being ignored. To this. So as y'all see, the state did not show up for court this morning, which is ironic because DeMonte Kendrick, aka Yak Gotti, represented by Doug Weinstein, filed a motion this morning talking about this very thing. Let's go ahead and check it out. The state of Georgia versus DeMonte Kendrick. Oh man, this is the motion. Check out this title too. This is a motion to time limit the state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. I mean, need we say more? This was filed this morning before court even started. So if this doesn't make even more of a case for this thing to be granted, I don't know how we can ever trust the Fulton County justice system again. The defendant, DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion. We just read the title, stating the following. As this court has broad discretion to exercise reasonable control over the presentation of witnesses and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiently, which we're seeing this morning with the state not even showing up for court. And the presentation of cumulative evidence causing undue delay, poor decision making by the jury, as well as harm to Kendrick and the other defendants. How were they harmed? A similar but not identical motion requesting limiting the number of state witnesses to less than 400, was filed with Chief Judge Glanville on March of this year, with the judge granting some limited relief, which has generally not been followed by the state. Judge Glanville, another example of him just doing whatever he can to help out the state in this case. Simply put, the court should put a reasonable time limit on clock on the remainder of the state's case. Man, oh man, can Doug Weinstein see into the future or what? The state has put and continues to put this court, these defendants, and the 16 jurors through an arduous, tedious journey. And YouTubers too. Don't forget YouTubers. We're all here struggling. The court should put an end to our forced march. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on in the trust that the next months will be different. That the state will develop the speed and efficiency of our finest Olympic athletes. This man's writing is amazing. And that the finish line of their snail-like marathon is in sight. God dang. At this point in time, the Honorable Court has borne witness to the state's unpreparedness, lackadaisical attitude towards any type of diligent approach to moving in a deliberate fashion towards a conclusion. But why should the state have any need to move with deliberate speed? The state returns home to their friends, families, and loved ones at the conclusion of each day. The state lives their lives, goes to work, and gets their paychecks no matter how long this trial proceeds. Meanwhile, for Yak Gotti and the other defendants, every day is Groundhog Day. But instead of waking up to Sonny and Cher, he wakes up to, I don't even know how to say that word. But shout out to Mr. Weinstein. He's putting some sauce on this one. It's flying over my head, so I'll have to go back and research that. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but is the governor of the trial for the purpose of assuring its proper conduct and of determining questions of the law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad powers of cope with the complexities and contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge may refuse to allow cumulative, repetitive, or irrelevant testimony. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. And I will guarantee you all, when we get back in court after lunch, whatever time that happens, the defense is going to have a field day. And Judge Whitaker, she's going to have to sit there and take it, because unless she puts a stop to this, y'all know it was mentioned in the past, actually 2 weeks ago, by Attorney Westmoreland. And she goes on and on multiple times saying, Judge Glanville already dealt with this. Judge Glanville already talked about this. Judge Glanville told the state and the prosecution that they should be on time. Judge Glanville told them they were limited to a certain amount of witnesses. Judge Glanville told them this. Judge Glanville told them that. And we're seeing Judge Whitaker even admonishing multiple times, and it's still being ignored. So I know Brian Steele, we know Westmoreland is going to say something. Mr. Weinstein is going to have a nice I told you so moment from this, because the irony of him filing this the day the state does not show up is ridiculous. It's just, if you get into the system, good luck to you. All right. You'll never, the odds are so against you. It's not even funny. So it's just best to stay away from it. We'll keep going though. The state, after originally proposing a witness list of over 700 witnesses, has a list of over 100 witnesses it still intends to present at trial. What specific evidence the state intends to use with each repetitive witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end to the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, which is important to point out, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. What's the cumulative evidence? He says, here we have a situation described so clearly by Judge B, we're going to say, in his oft-cited 1986 decision on limitations imposed at trial. The judge remarks with this insight: it would seem that early in the career of every trial lawyer, he or she lost a case by leaving something out, and thereupon resolved never again to omit even the most inconsequential item of possible evidence from any future trial. Thereafter, in an excess of caution, the attorneys tend to the attorney tends to overtry his case by presenting vast quantities of cumulative or marginally relevant evidence. In civil cases, economics place some natural limits on such zeal. The fact that the attorney's fee may not be commensurate with the time required to present the case thrice over imposes some restraint. In a criminal case, however, the prosecution, at least the federal system, seems not to be subject to such physical constraints, and the attorney's enthusiasm is virtually unchecked. And I think Judge B makes a good point here. We've seen that the state there's no sense of urgency. They're just taking their time with this. They don't care about these men that have been sitting in prison for over 2 years. They don't care that we're completely having to stop court proceedings because they're going to lunch. I don't understand what excuse they could come up with, but this is a problem that needs to be addressed. And I hope for everyone's involved that Judge Whitaker does address this. We'll see what her ruling is. As put so succinctly by the Third Circuit Court of Appeals, court needs not allow parties excessive time so as to turn a trial into a circus, which is that what this is. After all, a court's resources are finite, and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. Likewise, the prosecution here does not own this honorable court. Do your job, Judge Whitaker. This honorable court has a broad discretion on the presentation of evidence and should limit the introduction of duplicate or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, provides the trial court with a broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. Furthermore, this court can limit evidence under Rule 403 of our state's rules of evidence. We went over that last week, and he's going to read it through here. All right, we'll keep going and get down to the summary because a lot of this we've already heard before in past motions, and it seems like some of it was copied from some of the things Yak Gotti said in his previous motion. So here's the summary, and then we'll get back into it. While the state puts on this case, witness by witness, Kendrick and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Meanwhile, the risk of a confused jury unable to comprehend a years-long trial only grows. Wherefore, Mr. Kendrick respectfully requests that this honorable court to place a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. This on the 17th day of August. He filed it last night, but it's really this morning. Douglas S. Weinstein, Esquire, representing Yak Gotti. Well, there it is. Y'all let me know what you think. If you're watching the replay, you'll probably already know what's going to happen, but I want y'all to tell me in the comments, what do you see happening from this? Is Judge Whitaker actually going to do anything this time when it comes to this motion? Is she going to put a time limit on this? And what's the state's response going to be to this motion? I want to hear y'all's thoughts.